So my name's Todd Kukin. I'm a senior research associate here at the Woodrow Wilson Center. And we're here for the release of a new report that Margot Bagley and Artie Ray wrote for us on the Nagoya Protocol. And the reason that the Synthetic Biology Project at the Wilson Center is interested in this topic it was to take a broader look at some of these international agreements and how they may or may not affect the synthetic biology research community. And with this particular protocol, particularly on a U.S. focus. So the way that we're going to structure today is Margot and Artie are going to go over the report that they wrote for us, and then we're going to have Leonard Hirsch, who's from the Smithsonian Institution, and Paul Sarnoff from DePaul University comment on the report. And then after that, we're going to open it up for a larger discussion. I'd just like to point out this is being live webcasted, and we'd like to get participation from people who are watching on the webcast. When the question and answer period comes, if you'd like to send in a question, you can tweet your question to us, which is at SynBioProject. So that's at SynBioProject. And I will repeat that again later. Or if you would like to email your questions, you can email those directly to me. And that's Todd, which is todd.kuiken at wilsoncenter.org. So with that, maybe we'll go over the report. You want people to introduce them now, or do you want to do that later in the discussion?
I thought people could just
sure.
quickly
Okay.
introduce themselves now.
So if you want to move up, that would be great, so we can sort of see everyone. And I'll start passing a mic around so people can introduce themselves. Maybe we'll start here on the end.
I'm Len Hirsch from the Smithsonian Institution.
Josh Sarnoff from DePaul University.
Artie Ray from Duke Law School.
Margot Bagley from the University of Virginia School of Law.
Camille Dodebeck, CEO of SynBio Consulting.
Robert Herzog, I work for CVK Lobbyist Assist.
Bob McCrate, Penn State, and then periodically National Defense University.
Peter Utro, Environmental Protection Agency.
Nora Adams, Center for Non-Proliferation Studies.
Russell Michael, I'm an independent strategic planning consultant here now with the Commons Lab at the Wilson Center.
Olive Hopkins, retired.
Hello, my name is Takashi Ohama from JST, Japan Science and Technology Agency.
I'm Zamir Qureshi. I work with Burgess and Campbell.
Kamal Jain, law firm of Keller and Heckman.
Elizabeth Lyons, Department of State on detail from the National Science Foundation.
Rebecca Valentine with Center for Food Safety.
Hi, I'm Sarah Carter. I'm the policy analyst at the J. Craig Venter Institute.
I'm Justin Ursum at Wilson Center as well.
All right, thank you, everyone. So I'd like to turn it over to the authors, and then we'll go from there.
Great. So I was going to stand. Can people hear me, even though I don't have a mic?
Use the mic, right?
Justin, could you just hand her that one? It's just because otherwise the people on the
Oh,
web.
on the webcast, yes. Great. Well, thanks so much to Todd and also David Rajewski, who I think is not here, but who is also obviously intimately involved with all things SynBio, and the Woodrow Wilson Center for having Margot and me do the report and to have us out here to present it. I will do a short introduction. I am more of the SynBio person, and Margot is the person who knows everything about the relevant laws. And so just to tell you what the division of labor is in our little duo. So I'm going to give the basics of what synthetic biology is, maybe a review for some of you. So I'll try to go relatively quickly. And then also an overview of why I think that there are certain interesting, perhaps unique issues, not entirely unique, but perhaps unique issues that synthetic biology raises for both the conventional biological diversity which went into effect in 1993, and also the Nagoya Protocol to the CBD, which was adopted in 2010. And we think that these issues are relevant even for U.S. researchers, even though the U.S. did not ultimately ratify the CBD and is not a signatory to the Nagoya Protocol. So let me start with just a quick overview of our sense of where synthetic biology is. Now, synthetic biology, if you've spent any time toiling in this area, the definition is incredibly contested, and one could spend a whole conference just talking about definitions, which would be a boring conference, I think, but nonetheless a conference. So I will try to do this quickly. I think it's fair to say, and these are my words, not anyone else's, that one could think of synthetic biology as evolutionary or revolutionary, and there are different aspects of synthetic biology research that fall into those two kind of very simple buckets that I've set up. And the evolutionary approach, you could think of it as an extension of genetic engineering, just taking genetic engineering several steps further. From a revolutionary standpoint, and this is the standpoint that I think folks like Drew Andy are most associated with, their idea is that we want to make biology a true engineering discipline where standardized parts are combined into genetic circuits that produce very predictable outputs of various sorts. So just as we have electrical circuits that produce predictable outputs, we should have genetic circuits that produce predictable outputs in a standardized way. I think it's fair to say that we haven't reached that vision yet, and it's perhaps been overly, we've been overly optimistic that we might be approaching that vision. So I will talk about the revolutionary vision more in the if we get there category and what might happen with respect to CBD, NP if we get there. So I'll start with, however, with the evolutionary vision. And even before that, just to give credit to the Wilson Center and their fabulous synthetic biology project, I think one of the greatest visuals one can have on synthetic biology is their 2013 map of all the different places where synthetic biology is being done. And this map, which is interactive as well, and I've just given you an image of it, shows that at least in the U.S., several hundred entities are pursuing synthetic biology as of 2013, about 130 companies and 119 universities. I think it's fair to say that the companies, i.e. the private sector, have tended to focus on the evolutionary piece of synthetic biology, and their products thus far have been primarily in the specialty chemical area, in the medical area to some extent, and also in the biofuels area. I want to give a couple of examples of this evolutionary approach that has been adopted by a few sort of prominent companies for the purposes of motivating the analysis of CBD-NB. I don't mean to signal anything by the use of these particular examples. So to be clear, this is not meant to suggest that these companies are in a particularly interesting relationship in any way with respect to the CBD-NB. They're just offer simple and relatively easy to understand examples. So again, evolutionary example. So there's the famous case of Amyris and its mimicking, essentially, of the wormwood plant to make artemisinin. So the drug artemisinin is useful for treating malaria, but there are periodic shortages in terms of the natural product. Jay Kiesling very famously almost a decade ago now, started working on emulating the platform used by the wormwood plant. He ended up essentially taking genes from a bunch of different species and putting them in a yeast platform. One of the species included the wormwood plant itself. So wormwood plant genes were modified and put into the yeast platform. The original genes from the wormwood plant probably constitute, quote, functional units of heredity and hence genetic resources within the meaning of the CBD-NP. So if you look at the first part of the report, there's a glossary there that talks about what genetic resources means. And I think it's fair to say that genes quad genes from a plant probably constitute functional units of heredity. In this case, however, we have the interesting situation where Amaris has made modifications of those genes so as to optimize them for the yeast platform. Whether those are genetic resources is perhaps less clear, whether they're genetic resources, i.e. within the meaning of the CBD and NP, is perhaps less clear. There's also the question of whether they could be an application of a genetic resource within the meaning of Article 5.1 of the Nagoya Protocol. So that's just an example of how we might get some applicability of CBD and NP in the context of a current project. What about the ultimate product? In the case of Amaris, the yeast itself, the product that it produces is artemisinic acid, and that's ultimately converted into artemisinin using photochemistry outside the yeast platform. But the artemisinic acid could be a derivative within the meaning of NP to the extent that the formal definition of a derivative in NP is, quote, a naturally occurring biochemical compound that results from the genetic expression or metabolism of biological or genetic resources, even if it does not contain functional units of heredity, unquote. So here, the artemisinic acid is a naturally occurring biochemical compound. However, it was produced using a modified version of a genetic resource, not necessarily a genetic resource per se, so there's an interesting twist there with respect to whether it's a derivative in the meaning of the Nagoya Protocol in particular. A similar situation arises with respect to Genentech and DuPont and what they're doing with respect to the manufacture of isoprene. So they've taken genes from the rubber plant, optimized them for an E. coli platform, and are producing isoprene, which is also, of course, produced by rubber plants. Parallel analysis with respect to whether the modified gene constitutes a genetic resource, whether the product of the modified gene constitutes a derivative. Then there is the subsequent question of whether even information, genetic information, i.e. digital genetic information, could constitute something that was covered by either the CBD or the NP. That issue becomes even more of a question in the context of what I would call the revolutionary approach, which is the approach that Drew Endy and some of his colleagues are pursuing and have been pursuing for about a decade now. I first met Drew back in 2005, hard to believe. And that is the approach that relies upon the analogy to electrical engineering, essentially. We take standardized parts that perform particular abstract functions, and the information and the tangible materials are decoupled from each other, so the information can be transmitted and used, and subsequently the tangible material can be made from that information. So just to start with the abstraction and standardization piece, this is a slide from Linda Kale, of SINBERC, which is of a group that Drew Endy and others are involved with, funded by NSF. And I think it nicely illustrates the vision of the revolutionary approach. You take parts, make them into devices, and ultimately the devices are combined into systems. And here the system might be an engineered cancer-seeking bacterium. The part in question, and the part is what I want to focus on right now, in this case is a short non-coding DNA sequence called a promoter. So the question might be, in this case, is that a functional unit of heredity within the meaning of the CBD NP? What if this part is quite different from the part that would be found in any given organism? Does that make a difference? And this is important because there are actually lots of these registries now. So again, relying upon my friend Linda Kale, this is just a sample of different registries containing parts. Oftentimes, these parts have nothing to do with gene sequences that actually encode proteins. Rather, they're non-coding short sequences. And then, as I mentioned, there is the pure information issue. The goal, of course, of decoupling is to allow the gene sequence to be manipulated as information in all sorts of interesting ways well before anything is ever synthesized in any sort of tangible way. And so the question of what application, if any, the CBD-NP has to digital information, I think is a very interesting one. As we mentioned in the report, the CBD and NP don't speak per se to the issue of digital information, but certain countries' laws that were implemented pursuant to the CBD, which was it came into effect in 1993, do actually suggest perhaps encompassing digital information. So that's a very interesting set of questions with respect to the breadth of what's covered. So what I've done is, I hope, provide some insight into some of the interesting questions regarding the scope or breadth of CBD/NP coverage with respect to what is going on in the world of synthetic biology right now. I think in some ways the much harder question, you might think that, and I do think that the breadth question is hard enough, but even harder perhaps is the temporal scope question. And that is a question that really involves digging deep into the law, even perhaps more so than the breadth question. And Margot, who, as I said, knows all of the law in this area, is going to talk about that, and in that context start with a background on the complex history of the CBD-NP, and that background is necessary in order to really to address the temporal scope question. And she's also going to discuss the very interesting question of what enforcement might look like with respect to CBD-NP obligations under various countries' laws. So, Margot?
Thanks, Artie. And no, I do not know all of the law in this area. There's a lot to know, but it is a fascinating area. And I am going to give some background on the Convention on Biological Diversity, which really provided the basis for the Nagoya Protocol. So, as already mentioned, the CBD has been in effect since 1993. It has 193 parties that are signatory to it. Well, and not just signatory, but actually ratified it. It is an important treaty in part because of one of its key principles, the notion that states have sovereign control over the genetic resources within their borders. Prior to the CBD, there was a common understanding that genetic resources were more the common heritage of mankind, and people could freely use them and take them, and that thinking, at least, to a large degree shifted, I think, as a result of the CBD. So states have sovereign control. They should endeavor to make access to these resources available on terms of prior informed consent, and there should also be the fair and equitable sharing of benefits resulting from the use of genetic resources. Those are key principles. And the CBD also had 3 objectives. So it's in part an environmental treaty with the idea that it's involved with the conservation of biological diversity, sustainable use of its components. And then the third objective is where the Nagoya Protocol comes in, the fair and equitable sharing of the benefits arising from the use of biological and genetic resources. So the 2 environmental types of objectives, those are fine. People have been making progress on those. The equitable sharing of benefits arose from a concern that there was some inequitable behavior taking place, largely in relation to a term that's used, biopiracy. So ethnobiological research, researchers going from developed countries to biodiverse developing countries, taking samples, developing products and reaping lucrative rewards from those products, and not necessarily sharing those rewards with the providers of the original genetic material and associated traditional knowledge that kind of led the researcher in that direction in the first place. And so that's the idea that while providing access, there also needs to be the sharing of benefits. The CBD had as this third objective the need for access and benefit sharing and prior informed consent, but it was pretty vague on how you go about it. It didn't specify any particular methodology for countries to use. And so what we saw in countries implementing the CBD was a variety of approaches to implementing ABS and PIC to the extent countries implemented it at all. As we point out in the report, only something like 57 countries actually put in place biodiversity or benefit sharing legislation, and that's out of 193 countries. So there was a need, a perceived need for a uniform framework that would more directly address access and benefit sharing. We include some examples in the report of some of the various ways in which countries, particularly provider countries, and these would be providers of genetic resources. And when I say provider, I say predominantly provider because most countries are providers and users, but ways that provider countries implemented some of these access and benefit sharing provisions. So, for example, China has a number of biodiversity related laws, but they also included in their third revision to the Patent Act, which went into effect in 2009, provisions relating to genetic resources involved in coming up with a patentable invention. They have a provision requiring the disclosure of the origin of genetic material used in creating an invention, and also a provision saying that if genetic resources used to create a invention were obtained in violation of a law in China, then the patent should not be granted on that invention. A different approach we see in the Brazilian provisional law, and I should mention, in the implementing legislation, it suggests that violation of a law is a basis for not granting a patent, but not a basis for invalidating a patent that has already been granted. And Josh, we were talking a little bit about whether it's possible to do that in a re-examination proceeding. It's not at all clear, but at least in the implementing legislation, it suggests that it should not be the basis for invalidating a patent that is already issued. Different approach, as I mentioned in Brazil, the provisional law there relating to biodiversity. There are a variety of options available to the government for violations of these laws. There, a patent actually could be suspended or canceled if it was found that the invention covered was made with resources that were obtained in violation of the biodiversity law. Alternatively, the government could impose a benefit sharing obligation on the violator of at least 20% of the gross income or royalties from commercializing or licensing a product, so mandated benefit sharing. And a different approach, and India is not the only country with criminal penalties, but if someone fails to obtain permission before accessing genetic resources or even before filing a patent application on genetic resources that were accessed without permission, the penalty could be fines or imprisonment, and even for attempting to contravene this provision. So that's a little scary, but another approach. And again, there are very strong feelings in many quarters, it's particularly in provider countries, that indigenous groups and the states themselves had perhaps been treated unfairly, and wanting to make sure that there was going to be the fair and equitable sharing of benefits. Unfortunately, a problem with these kinds of provisions that were particularly onerous is that instead what we've seen in many cases is a reduction in folks trying to obtain access to the resources in those countries. All right, so we have this variety of different approaches to implementing the CBD. No real consistency to the extent countries were implementing the law, the provisions at all. That ultimately led to the Nagoya Protocol. It was adopted in 2010. It has 92 signatories, and it is scheduled to come into effect after 50 parties ratify it. And it creates a framework for access to genetic resources and associated traditional knowledge. And by its terms, it is the instrument for implementing the access and benefit sharing provisions of the CBD. So CBD is 1993. We've got many years later, finally, an instrument that is supposed to implement that third prong, that third objective. The Nagoya Protocol itself has two main prongs, access and user compliance. So as I mentioned, a number of countries that did actually implement access and benefit sharing legislation were provider countries. And so they've got these laws that penalize violations of the biodiversity provisions of the law. But on the other side, there's not legislation in user countries that would support and give effect to that. And so that's what many of the provider countries were looking for, obligations as well on the part of the user community and a compliance mechanism to make sure that the laws are complied with and that benefits are shared. I have some of the provisions of the Nagoya Protocol here. One point is countries are not required to mandate prior informed consent, but if they do, then they have to follow the requirements that are listed in the Nagoya Protocol for access. Countries are supposed to designate national access and benefit sharing focal points that could be a place where users interested in finding out how they access genetic resources and come up with these benefit sharing arrangements, information that, a place that they can get that information. Also designation of compliance checkpoints. These could be a place like a patent office if you're filing an application for a patent using a genetic resource, a checkpoint as to whether you have complied with necessary ABS and PIC provisions in relation to the genetic resources used in creating your invention. Also the possibility for countries to create internationally recognized certificates of compliance that they would give to users who could then show at the checkpoint, see, I've complied with ABS, I've complied with PIC, I'm good, I can move forward. And again, of course, the genetic resource utilization benefits needing to be shared in a fair and equitable way. The Nagoya Protocol also obligates parties to cooperate in cases of alleged violations of access and benefit sharing that may have taken place in other countries. This very small type you really can't see, but I wanted to show it. It's from an explanatory guide by Thomas Greiber and others. And it shows some of the complexities that can arise in trying to figure out whether you're subject to access and benefit sharing requirements. And there are complexities because that can be related to the source of supply of the genetic resource, whether it's from an ex situ or in situ source. The purpose of the usage, is it for commercial or non-commercial research? Here we can see, particularly a synthetic biology issue, the relationship between the genetic resource and products, whether there's a close relation or whether, for example, there's not a close relation, and they give an example here, the function of an organism or its parts serve as a model, mimics in material research and biotechnology. So that's considered not closely related and then not related at all. And then characteristics of material identifiable before utilization. So various permutations you can have. It can be a difficult minefield, in a sense, to navigate in terms of figuring out whether you are covered by a particular country's law that could be used to implement the Nagoya Protocol. All right, so in the report, we focus on three particular implementation issues with relevance to synthetic biology researchers. I already mentioned the pre-Nagoya Protocol biodiversity laws. I will say a little bit more about those. The fact that they vary quite a bit and that they impose penalties and liability irrespective of the Nagoya Protocol. I'll spend a bit more time on the temporal scope disagreement, and already highlighted the breadth of coverage issue in terms of whether materials used and developed from synthetic biology would be covered by the agreement. One of the challenges that we have is that we really are in early days regarding the implementation of the Nagoya Protocol. Early, not so much from a time standpoint. It was adopted in 2010, and we're here at the end of 2013. But early in terms of countries actually providing, implementing legislation. Right now, legislation that has been submitted to the Conference of the Parties of the CBD for the Nagoya Protocol, these are the only countries in the EU that have provided it so far, and most of that legislation is not in English, not easily accessible. So we don't, and it's mostly draft legislation. We don't really have a good sense for what countries ultimately are going to do. But the temporal scope issue is an interesting one, and it's an important one. And the question is, what genetic resources, however we ultimately define them, does the Nagoya Protocol apply to? Okay? And we've got different points in time that we can look at. Folks are pretty much in agreement that genetic resources accessed after the Nagoya Protocol goes into effect, whenever that may be. Some folks say around 2015, no earlier than 2014, clearly, that those would be covered by the Nagoya Protocol. The tougher question is, what about genetic resources accessed prior to that time, either since the CBD came into effect or even those accessed before that time, because there are, of course, many genetic resources in a number of places that would fall into this category. That has raised some interesting questions, in part because the Nagoya Protocol doesn't directly address that. And I should point out that while a consensus was reached on the Nagoya Protocol, it's an agreement that none of the parties were really happy with. It was, the final text was a result of last minute, take it or leave it document, basically, that had stripped from it many of, or most of, the controversial provisions. So there's a lot that it simply doesn't address. The scope provision, says that it applies to genetic resources within the scope of the CBD and to the benefits arising from utilization of such resources, but it doesn't say when, okay? So we don't have a time period. Now, the Vienna Convention, which is a treaty on how treaties are supposed to be interpreted, tells us that unless a treaty says otherwise, its provisions do not bind a party in relation to an act or fact which took place before the date of entry into force of the treaty. That would suggest that since the Nagoya Protocol does not specify a time, temporal period, that the time period we should be looking at is after the Nagoya Protocol comes into effect. Though I must say there are examples in international law where that rule has not exactly been followed, and we can talk about those in the Q&A if anyone so desires. So what we see in the draft EU Nagoya Protocol implementing legislation is that approach, that the regulation only applies to genetic resources and associated traditional knowledge that are accessed after the entry into the force of the Nagoya Protocol. The problem with that is many countries, around 20 or so, so I don't know if we want to consider that many, but a number of countries have in their CBD implementing legislation provisions that either define or create liability for utilizing genetic resources. So I've got an example there from the Andean Community decision, and that is also actually consistent, it can be argued to be consistent with the Nagoya Protocol Article 3, because it says it applies to genetic resources within the scope of Article 15 and to benefits arising from utilization. So the argument is, well, we should focus on when the genetic resources are utilized, not when they were originally accessed. Okay? They could have been accessed years, decades before, but if you're making a use of it now, then you should be subject to the access and benefit sharing requirements of the particular country from which those genetic materials originated. And I've got a quote here that's also in the report. There are some NGOs and actually an EU rapporteur that actually are very concerned about the EU approach. And just to share this, they note the fact that a significant share of genetic resources and associated traditional knowledge used in the EU would not be covered by the regulation, since it only focuses on genetic resources accessed after the Nagoya Protocol comes into effect. Also, individual users of genetic resources in TK will not be able to receive what they wanted, which is legal certainty, because you're going to have different rules in different countries. And they also point out that this undermines the spirit of the Nagoya Protocol. In many cases, utilization will be legal under EU law, but illegal under the law of the provider country. Although the users received an approval from European authorities, he or she could be prosecuted, if you take, for example, the India legislation, in a provider country upon setting foot in that country. So instead of providing the certainty that parties were really looking for in this area, the Nagoya Protocol leaves this really big issue unresolved, and for countries to decide as they implement the agreement. So how is this all relevant to U.S. synthetic biology researchers? One might wonder, since the United States is not a party to the CBD, why it even matters. Well, the CBD was signed by President Clinton. The Senate did not ratify it, so we never actually joined it, and we're also not party to the Nagoya Protocol. However, the United States has been an observer in the various negotiations relating to the Nagoya Protocol and other CBD protocols. But the ABS, PIC, and Nagoya Protocol implementing legislation is still relevant to U.S. researchers, because that's where you're more likely to run into a problem. It's on the ground in these individual countries that have developed legislation or are developing legislation in relation to Nagoya. And I've got a couple of examples of enforcement of ABS laws, and it's not that we've seen a lot of enforcement thus far. We haven't. Apparently the first case under India's Biological Diversity Act is just recently being brought. It was brought in 2012 against Monsanto for accessing 10 varieties of Indian eggplant in development of their BT brinjal product without complying with the ABS PIC requirements. And also last year, a Brazilian agency fined 35 companies, and these were Brazilian-based multinational corporations, pharmaceutical, cosmetic product companies, a total of around $44 million for violations of ABS and PIC for either not sharing benefits or falsely saying they'd shared benefits when they hadn't shared benefits. It's interesting, though, in the report that I read, a government spokesperson says, well, you know, we want to encourage companies to do business, so there's a possibility that they can get not up to 90% of the fines remitted if basically they promise not to do it again and to implement transparent procedures for ABS and PIC. And there's also the possibility of appeal that these companies can use. So enforcement, is it likely that an individual researcher or a particular NGO is likely to be prosecuted? Not necessarily. We haven't seen a lot of it, but it's something that's out there. And so from a best practices standpoint, and you can't read this one at all, there are a number of tools and guidelines and handbooks that have been put forward to help researchers navigate and figure out when they need to request access and create a benefit sharing agreement under mutually agreed terms or not. This pathway is from the revised ABS best practices handbook, and it kind of takes you through a flow chart. You know, if this is the case, then this, if yes and no. Very helpful. Bio has also created guidelines to help researchers in figuring out when they are likely to be subject to ABS and PIC requirements. And so all of those types of things are helpful, but they're more helpful in relation to, again, the national laws as opposed to the Nagoya Protocol itself, which for the most part has very vague language, and it's ultimately going to depend on how countries implement its provisions. So in conclusion, the Nagoya Protocol implementation really matters, is what matters for U.S. researchers. At this point, we can expect continued uncertainty and a lack of uniformity regarding temporal scope and coverage of synthetic biology components until the implementing legislation is in place, and even then we'll have a lack of uniformity. But something that researchers might want to do is consider possible ways to influence legislation as it is being developed. That's something that the Smithsonian has been involved in very usefully, and that's something that the U.S. government as well, in terms of lobbying and encouraging various states in the way, in understanding the importance of particular issues and the ramifications of enacting particular types of provisions. So with that, I will end and turn it over to Scott.
Yeah, so thank you very much. Now we're going to have Josh Turner from DePaul give some comments, followed by Leonard Hirsch from the Smithsonian, and then we'll open this up for discussion.
Okay, well, first let me also give my thanks to the Wilson Center for doing this, and to Artie and Margot for focusing on a topic and asking me to participate, which brings me back a decade. It's nice to have your friends also be really excellent scholars. And I think that the main benefit of this paper is it brings to attention the need for the synthetic biology community to really get engaged in these issues, and I think that's a really important development, particularly at an early stage before foreseeable problems develop. You know, an ounce of prevention is worth a pound of cure, and clearly here there's much that can be done for prevention. However, that said, I would encourage the authors, if not in this report, then in subsequent ones, to push the analysis farther. And in particular, although Margot in particular referred to a number of complexities, and I'll follow basically the order of complexities that they focused on: national legislation, temporal scope, and subject matter scope. It would be incredibly helpful for them to actually provide further analysis, starting with national scope or scope of national legislation. It would be really helpful to know what the Nagoya Protocol actually requires, permits, or prohibits. And those are three different things. Much of what the analysis talks about is what the Nagoya Protocol either requires or permits, but not at all what it might prohibit. And in some cases, the discussion, it permits one thing, but the real interest is, does it permit the other thing? So let me just give you an example of that. They note that the Nagoya Protocol is, after discussing this question of how access is defined, whether it's defined by removal of materials or utilization of genetic resources, and many countries will view their national CBD implementing requirements that were imposed before the national Nagoya Protocol to apply, notwithstanding the Nagoya Protocol. They note that the Nagoya Protocol is silent on when access happens, and then they ask the question, may they, do so whenever it's accessed for use later. But the question is, does the Nagoya Protocol authorize that, or is it just that they can do so because the Nagoya Protocol doesn't prohibit it, right? So again, I think just greater clarity, further analysis would be really helpful here. That said, they're also extremely careful and just very calm scholars. So I want to encourage them to ratchet up the rhetoric, at least, to make it clear that these are just much more highly contested issues than you would think. And from reading a paper, you think these are clinically analytic questions, when really what much of the debate is about refighting colonialism. So if we get to the question of the history of going to all of these materials that are now outside of the countries of origin in situ repositories that came during a time when they might have been accessed legally, if you assume that colonial occupation was for hundreds of years legal, or they might have been obtained illegally during the colonial occupation. Do the countries which we've now declared have sovereign ownership over those resources have an interest in those materials and in the commercial benefits that might be obtained? Will they be happy to sit back and say, oh no, the Nagoya Protocol doesn't cover it? You can see that this is not just going to be a legal question, it's one that has the potential for the scientific community to actually have serious public relations issues that will develop. I'm sure Len can say something about that. I'll leave it at that. So again, this is not just a cold, unemotional question of what the scope of this is. Margot alluded there were differences of opinion in the negotiations. That's a calm way of saying that people were at each other's throats and couldn't agree, right? I mean, this is a very different dynamic that's going on. Okay, so even if the Nagoya Protocol or even the CBD doesn't require something, do they prohibit something? And even more, there's another question, do the other forms of intellectual property agreements or trade agreements prohibit something? I'll refer you to an analysis, this is why it brings me back 10 years, that Carlos Correa and I did. You can access it by Googling UNEP/CBD/WG-ABS/4/INF/2, where we tried, at least for purposes of analyzing the existing CBD obligations in relation to national implementing legislation, whether the national implementing legislation would violate any of the existing IP treaties. Here we have the question of whether or not these types of requirements are actually requirements of intellectual property systems that we do regulate, things like formalities, disclosure obligations, or they're really questions of ownership. To the extent that they are actually questions of ownership, and these are questions of unfair means of acquiring ownership, we have questions of whether courts in other countries will first recognize the temporal choices that are made by other countries, whether or not they will recognize violations of foreign law and allow their own courts to enforce them, questions about whether or not they will adopt their own equitable restrictions on enforcement in their own countries under their own law, and so civil law jurisdictions, questions of unjust enrichment claims that could be provided. This is a much more complicated area, much more fraught with potential problems, which is why bringing attention now before those problems develop is really a wonderful thing. So let me then switch to the question of not the history of colonialism and the temporal retroactivity concerns, but the scope concerns. And I'll use the example that they point out. Indian law applies to biological resources. Biological resources under the CBD include genetic resources, but normally the word include means include, but are not limited to. So therefore, we're not just talking about national laws that are addressing genetic resources, even assuming that genetic resources apply to functional units of heredity, even assuming that the question's already raised about what is a functional unit of heredity and therefore and Nagoya Protocol or CBD regulated genetic resource is expansive or narrow. Further, we get the issue of derivatives. Interestingly enough, the Nagoya Protocol does define derivatives, which the CBD doesn't. And in doing so, of course, there is no operative provision of the CBD or the Nagoya Protocol that turns on this definition or word derivatives. What does that suggest? In contrast, there is a provision that deals with, give me a second, biotechnology. Give me a second. So the operative provision for biological resources is defined in regard to conservation obligations, which is Article 8C, biological diversity, which is the obligation to respect and encourage benefit sharing for traditional knowledge under 8J, and genetic resources are the ones that apply to sovereign ownership, prior informed consent for access, and benefit sharing. In contrast, The biotechnology, which is defined as any technological application that uses biological systems, living organisms, or derivatives thereof. So it clearly does encompass the types of things that Artie was discussing. The concerns that are raised are principally for the release of genetically modified organisms, Article 8G, biotechnology transfer for use of biodiversity and genetic resources without causing environmental damage, Article 16.1, and benefit sharing of biotechnology based on genetic resources, which is Article 19.2. Again, it doesn't define derivatives. So we have this mass of stuff in the CBD which doesn't have any clear set of defined obligations, which is probably going to be found to be permissive rather than prohibitory. National legislation, therefore, could apply to derivatives. And then we get the much more difficult question, what do we mean by a derivative when we are talking about digital information? Well, then you're going to invoke the difficult questions of what are joint owners and joint inventors under the traditional or non-traditional aspects of intellectual property laws, typically patent laws, when you transfer information that is the basis for somebody else coming up with this conception of the new synthetic thing. That's an area that's fraught for dispute. Joint inventorship disputes are rampant. Rampant's probably too strong. There are still a lot of them. And the more we do information sharing across borders, the more likely it is we're going to see these things, particularly if they're fraught with the overlay of colonialism. So, in conclusion, they suggest 3 perfectly reasonable and sensible steps that the researchers in the U.S. could engage in. But then they note there will be continue to be a lack of uniformity and legal uncertainty for researchers using genetic resources in their work. Moreover, failure to comply with ABS-PIC provisions of any country, but not material agreed terms provisions, don't know, of any country may affect the ability of researchers to obtain IP rights, certain kinds of funding, or other benefits in the jurisdiction such as the EU. This is clearly correct, but it's said so quietly when it should be a big deal, and it really understates the problems of non-uniformity of the system. The only way to get uniformity of the system is to mandate both requirements and prohibitions on going beyond, which in the current context will never happen. So therefore, we are facing a huge cost on researchers if they're going to act responsibly to learn and regulate themselves in a system where they have no idea what will happen, where negotiations of even identifying who the relevant parties are may be difficult, and worst of all, where the rules from one country may not be the same as the rules from another country. So one country may choose to enforce the rules of yet a third country, and the second country might not. It's going to be a mess, and I therefore just encourage them to take the analysis further with actual recommendations for how to clean it up.
Bravo, and I agree, and I'll make it a little worse. One of the states in India 2 months ago used the National Biodiversity Act to say that coal was a derivative of biological diversity and therefore is claiming jurisdiction over mining rights. So the derivatives language is going to be quite fascinating as it plays out.
Did we specify which dinosaurs they were referring to?
Which we know were Indian. Thank you very much to the Wilson Center for the papers, for the comments. As someone who has been one of the observers for this since the beginning, I've earned all of the gray hair. CBD and Nagoya are a recognition that while sometimes, as Henry Kissinger said, you want constructive ambiguity, that ambiguity is often not constructive. And in this world, it has been very non-constructive, and I think we see a lot of it here. So one of it is I want to do a little history fixing. which I think is very important, especially if you're going to go on with this and redo the paper, because you're missing a very key element from the beginning. And biopiracy wasn't an issue in the 80s when this was being negotiated. That gets grafted on much later. The ABS provisions, and I want to mention that the term benefit sharing as benefit sharing actually was never discussed, which is what undergirds this. And there was another vital part of CBD and ABS, which was on the screen but never mentioned, which is MAT, which is mutually agreed terms. And I actually want to bring both of those very much into the discussion because they deal with some of the concerns that have been brought up, not in ways that everyone's happy with, but they actually deal with it. So why do we have an ABS provision? When the U.S., and the U.S. was the country that proposed a biodiversity treaty as a conservation treaty, in the discussions running up to the Rio World Conference, it was a time when the developing countries, as a bloc, really were sort of saying, okay, what's in it for us? You want all of this stuff. You want a carbon treaty, you want a forest treaty, you want a biodiversity treaty. So you're telling us not to use our forests, not to use our biodiversity, not to use our forests. This ain't going to work. Which most of us negotiating had, agreed with. At the same time, we were told by the administration, by the White House, that there would be no new ODA, no overseas development assistance. This was not going to be a issue of more aid. We had to find market mechanisms, new ways of finding the resources to be able to do the necessary flows of resources necessary to do the aims that we wanted, whether it be climate change, whether it be the protection of biodiversity. So in climate change, okay, carbon markets, these were going to be easy. We know how to do markets. And they were supposed to bring lots of money to those who were protecting carbon and therefore pay for itself. It's been a long time. We haven't had the money yet, though we still know how to do carbon markets. ABS was even much more innovative because we actually didn't know how to do this. But we were trying to create a market. And as you very correctly pointed out, tried to delimit that market, that this wasn't about all biological materials. It wasn't about trade in grain and cotton. It was something new, a subset which we really didn't know how to deal with. And the gobbledygook language that got created was this genetic resources language. And there's a lot of history on why we ended up with that. But it was clearly to be a subset. It was clearly to be on new issues. And it was clearly to spark research such as synthetic biology or new uses of products. The whole hope and the dream, and if you read all the papers that came in, the green gold papers, was that having a process which said prior informed consent, which is a government thing, but the real important one was the mutually agreed terms, which is that when you went in and did research, you were giving me X product, and I was agreeing that if I commercialized it, I would give you a percent of whatever the agreement said. But it wasn't telling me it had to be 3% of profit or 2% of gross or whatever. That's what the mutually agreed. It was going to be negotiated, and we would all agree that there would be some, and it would spark certainty. It would have certainty that would spark the invitation in of research, and it would become a engine for development in highly biodiverse countries. Well, what happened is the highly biodiverse countries said, oh, well, what's the right amount? Is it 2% of gross? Is it 8% of profit? Is it? We don't know. So rather than inviting people in, they actually stopped people from coming in this very long process that led up to the bond guidelines of trying to figure out what was the right way to do it. And that's when some of the biopiracy stuff started to come in. And I agree with you. Now, there is a whole group, almost none of them from countries. You know, this is a bunch of NGOs who do want to make this a redo of colonialism. But the treaty doesn't. The treaty is actually, and that's why Nagoya Protocol, the Article 15 reference, if that had not been there, this would not have passed. Because that goes to Article actually 15.3, which is that it is, have to read the right thing, which is the resources acquired in accordance with this convention, i.e. it isn't retroactive because you acquired it under the convention, and under the convention meant under mutually agreed terms. So in reality, while people want to make it bigger, the language that's here is that we have a process of getting material, using it, and having an agreement, and then having benefits go back. Why haven't benefits gone back? One, because most countries haven't signed agreements. So you have the Bolivian ministry saying, we're proud we haven't signed a single agreement. Where are all of our benefits? Well, if you don't sign an agreement, you can't get the benefits. Because the system is set up as a transactional system, that there's an agreement, a utilization, and a flow of resources back based on the utilization. If you don't allow utilization, the benefits don't come. So we have this continued series of cycles and problems with it, which have raised expectations and continue to raise expectations and continue to create frustrations. Now, where SynBio comes in, I think the question of information, the utilization of parts that may not fit the even vague definitions that we already have and have not dealt with, I think are key issues here. CBD for many years, I think has been a full employment act for lawyers, and Nagoya Protocol will be even more so. Because I think it's a real interesting question that if you mine a database for something that's like something, where is that nexus? CBD is based on a nexus. It's based on this genetic resource led me to this product. Well, if you're not using, and it's the utilization, if you're not using it, but you're using information about it, but never going to it, when does that nexus break? And this will be, I think, a very big issue. People have to be ready for it. You have to be ready for all sorts of lawsuits. And the equity questions, you started with the Artemisin story, well, might be perfectly legal, but then you're going to get the same group who are talking about colonialism, talking about how many people you're putting out of work in China. And so as a community, the community needs to be ready to be rather violently attacked, using the internet, not using careful analysis, and understanding that it comes from a whole series of ambiguities to start with. And I think that will continually get in here. The final one, which again is problematic for researchers, industry, who are working on issues, is that very frequently the agreement that you end up with, the material access agreement, mutually agreed terms, is actually not with the government. It's with a landholder, it's with a rights holder. And so we have a very odd mix of requirements that are governmental here. You have to have prior informed consent, and that is generally with the government. That's a research permit. but your mutually agreed terms on the use of that, in some places it's the government. Brazil has nationalized everything. India has nationalized everything, but now the states are taking claim over what's there, and there's a fight going on in India between the national and the local on who actually has the rights. Argentina, it's down to the state level. Malaysia, it's down to the state level. In the U.S., it's down to the landholder. I mean, so my backyard, you know, my flower pots, I can sell the soil there to anyone, and I have the rights to it, and DC doesn't, and this country doesn't. You know, but the Park Service has its rights, and the Air Force has its rights, and you have yours. So those, getting those set, and then, you know, companies merge. So one of the biggest, you know, cases was the Kenya case, which was a ridiculous one, but it was, you know, pre-CBD material that had gone to a lab. The lab had, you know, sent it to a company. The company had been bought by another company, which had been bought by another company, which had been bought by another company, which finally looked at it and said, oh, this is something useful. How do you develop the reach, the transparency, the traceability straight through all of the transaction sets is very difficult. And that's where, you know, from the Smithsonian perspective, we don't do the commercial work, or very, very little, but we share material back and forth a lot. Things get separated, things get fractured, and having that traceability is a big cost, an enormous cost, and it's a cost to science, and it's one that all of the labs really need to be thinking about. I'll stop with that.
That's great. So while you guys, I would like you guys to respond to that. And I just want to remind people on the webcast, if you have questions, you can send them to our Twitter account, which is @SynBioProject. And just quickly to sort of address sort of moving forward, one of the reasons why we wanted to do this report was to sort of bring these issues up to the synthetic biology research community. Because as we move forward, we plan on having more of these discussions directly during the UN negotiations. And in June of 2014, this COP, the Conference of the Parties that was mentioned, is going to be discussing synthetic biology in these terms. And we hope to have an event there to sort of bring the research community and others involved in synthetic biology, in a sense, directly to the UN negotiators. So if you're interested in those types of projects and working with us, please shoot me an email or call us, because we're going to be developing those types of programs moving forward, so we can start getting the synthetic biology community more engaged in these discussions. So with that, I'd like Artie and Margot to respond to what they heard, and then we will open it up to people in the audience.
Hey, well, I really appreciate the comments by Josh and Lynn. It's really, really helpful, and especially to have someone who was there at the CBD negotiations, because when you read the literature, you get sometimes a different perspective. And I totally agree with you that the term biopiracy is certainly a newer term. I think, though, and again, from the literature, the equity concern, though, and maybe it was still inchoate at the time of the CBD, but as I understand it, and this might have been something I should put differently in the report, is, of course, the ethnobiological research had been going on for decades, but something that changed in 1980 was the Diamond v. Chakrabarty decision saying that you can patent biotechnology, and that, in a sense, profit in a way that perhaps you couldn't previously from some of the types of research that was taking place. And so there's one article in particular that talks about the notion of granting property rights on biotechnology, then created, and this is Professor Safran, Sabrina Safran, a chain reaction of wanting to propertize more natural resources. So that's what I was kind of trying to get at, but you're absolutely right. The biopiracy as a term certainly was much later, and I totally accept, you were there, that if folks weren't talking about the equity, then that's very helpful to know. And the retroactivity point you make is also a very good one, but I think you're also point out quite well that the ambiguity of the agreement is problematic, and the ambiguity of even the scope provision referring back to CBD Article 15C, and then yet talking about utilization. And so there's room for people to make reasonable arguments that certainly post-CBD genetic resource access post-CBD, but utilized post-Nagoya should be included. And it's a problem. It's a real problem.
So I would like to also really thank both of the commentators. It occurs to me, and I come at this from more of the synthetic biology domestic community, because I've been involved with that community for now going on 8 years, from when I first met Drew Endy, that the synthetic biology domestic community, at least the US community, has been acutely aware of the anti-commons type possibilities with respect to intellectual property. So more so than really any other community, scientific community that I can think of, the synthetic biology community has really reached out to patent lawyers and patent professors and tried to figure out what the patent anti-commons type problems might be with respect to upstream patenting. I don't think that the community has nearly focused as much on Nagoya. I think in part because it is so incredibly complex, and I'm having come at this from really the perspective of an outsider to the Nagoya piece of things. I'm amazed by the complexity. It completely, I think, overshadows the complexity of trying to do patent mapping on U.S. patents or even international patents, because at least there you can search for the patents and you know what the patents say to some extent at least. And then you have court decisions that you know are law that will have an impact on the patents, and I think as a consequence of cases like Myriad in particular, that anti-commons problem is reduced. But it seems to me that the community needs to get now involved in what is clearly the more important anti-commons problem going forward.
Yeah. And one other thing, we weren't really charged with writing a fully comprehensive report about all of the different aspects.
Right.
So I just wanted to add one more thing, which kind of links something that Len said with where you started in your talk, Margot, and that is that the CBD has unfortunately to date been a tremendous disappointment in terms of its bioconservation goals. And the hope was that there would be enough money through these material of the agreed terms and access agreements to make it profitable. My instinct is that given the amount of material that's outside of the countries and given the ability and increasing ability to digitize and analyze, that it's going to push the issue of development into the external and information areas, which only drives the conflict, because conflicts follow money much more dramatically to try to address those issues. And as I say, even if one says the Nagoya Protocol is limited, the national legislation may not be. So,
no, and I'll actually absolutely agree, which is why as a community and industry in this country and SynBio, which is going to be on that bleeding edge, needs to be ready for, needs to look at Article 10 of the Nagoya Protocol, which creates sort of the out that breaks the nexus between this and that, saying that, okay, if we can't figure out where it came from and all of that, we're just going to create a multilateral fund, put money into it, and then you'll be okay. And it may simply be that should Nagoya go forward, I'm not certain it'll get 50 ratifications if the EU doesn't. Article 10 and the setup of that is going to be the only palliative that will exist for thousands of lawsuits.
I want to open it up to questions here in the room, and then also, again, if you have questions from outside the room, you can send them to our Twitter account, which is @SynBioProject, or you can email me directly, which is todd.kuiken@wilsoncenter.org.
Thank you. I'm Peter Utro. In a previous life, I was U.S. negotiator to the Biodiversity Convention for a number of years, and I wanted to congratulate Len in particular on a remarkably good memory on virtually everything you said on One Went On. I have one quibble. There was actually extensive discussion on benefit sharing, although much of it was behind the scenes, and it was led by India, Brazil, and Sweden. So the concepts were, in fact, there starting in about 1989, I would say, and continued to percolate through the discussions. But I had kind of 3 points I just wanted to make. One, I think it most interesting that Cartagena wasn't mentioned at all today, and yet the issue that seems to have perhaps the greatest attention right now on the part of both the synthetic biology community and domestic regulators is, in fact, the issue of biosafety. And biosafety, not in the sense that it's generally thought of in the community, but in terms of threats to biodiversity, which is what the Cartagena Protocol was about. The second point I wanted to make is that where you draw the line between kind of classical or not quite classical genetics and synthetic biology will have an enormous impact on what this all means. And clearly, at least Big Pharma recognized this a long time ago, that this treaty was a mare's nest. And there was a huge shift of investment from bioprospecting into rational design. And I suspect that that offers far greater opportunities for the synthetic biology community even than it might have in the past. And that will, in essence, offer the possibility of making the Nagoya Protocol irrelevant to the synthetic biology community. And finally, to echo Dr. Sarnoff's last comment, I think it's also interesting that the concept of the common heritage of mankind, resources, which originated in Stockholm in 1972, 20 years later was essentially destroyed by this treaty, and it is worth remembering that its purpose was to try and allow other countries to help lesser developed countries have an excuse for protecting particularly spectacular landscapes or resources, parks, other things like that. And yet that kind of got wiped away with the move to sovereignty that was based exclusively on genetics. And that I've always regarded as a very unfortunate sequel to the convention.
So I can comment on the whether Symbio will move to rational design piece of it, because that goes a little bit more to my particular area of focus. I'm not sure. I think that, the pharmaceutical industry's, foray into rational design has not necessarily been a completely happy one, to put it mildly. And the fact is that, organisms in nature do provide good templates for all sorts of things. Evolution has been around for many billions of years, and even though the synthetic biology community thinks evolution is far less than optimal, they still look at it and then try to make it better. So, that's where I would differ a little bit, I think. I'm not sure that rational design, the fact is that chemical synthesis of artemisinin would just be cost prohibitive, and so that's why they decided to do it in a biological chassis. And I think that, that's why I don't think it's going to be as easy as just shifting away to a completely industrial, non-biological foundation.
So I'll just pick up on the Cartagena point and make two comments. The first is that we've seen all these issues with GMOs and public reaction. I think the reaction to synthetic bioproducts is potentially going to be much greater. So I think that issue is out there. But what would really drive it is if during the course of the next negotiation over access to the genome of the viruses coming out of Singapore or wherever, someone stands up and says, sure, you own it, but you also have state liability, right? That will totally change the entire discussion, right?
Also, we, just to, again, to reinforce Margot's point, we really were tasked with addressing only IP and not really biodiversity or risk.
If I may, because this REACH question is fundamental to how this is going to play out over the next few decades, and though I love your liability issue. So you talked about it is important because you were using a biological envelope, and interesting, that is not the part that I think most ABS people will be concerned about. It's that, and this is where I think we need to pull it out, is it simply, if you're using a biological envelope to do it, it's covered by Nagoya's CBD. That's an interesting one. And then where do you get the yeast or whatever?
Oh, no, I don't mean the envelope. I mean the stuff, the device or system that you put in the envelope.
Mm-hmm.
So I don't mean the chassis.
Okay.
I mean, but I think you're modeling your system. Typically, at least you've taken a peek at what nature has done.
So the question, that's exactly where I wanted to go, because it's this nexus question. It's the utilization.
No, precisely.
Of.
Precisely. Yeah.
And when does that stop?
No, exactly. And that's where I think Margot's point about, not closely related comes in. What's the line between closely related and not closely related? And that's a huge nightmare.
Mm-hmm.
Let me just again add, we have concepts of joint inventorship, which could be
and those have not worked out well either.
I understand, but in other contexts, just to make the point even more difficult, in other contexts, such as the Copyright Act, we deny protection over aspects that people have incorporated into their copyright works without authorization. So these issues could get even more complex.
Yeah, so it's interesting that you brought up joint authorship because in the context of patents, at least, I've spent a lot of time thinking about all the impediments that patent law raises to collaboration because of the nightmare that is joint inventorship. So.
I want to pick up on the question of biosafety and biosecurity, because if you actually read some of the draft documents that have come out of the UN on the CBD and Nagoya, there's a gap analysis document that they put out where it does raise these biosecurity and biosafety questions, which to some of us was a little concerning because we didn't think that was incorporated into this protocol. So those are additional sort of questions that we'd like to sort of raise that people to become aware of, because there's a lot of sort of language that's been floating out there that are, in a sense, in draft form at the moment that are going to be in these discussions that are coming up in June, at least at the start of those discussions in June. Yes, back there. Can you just wait for the mic and just so people on the web can hear you?
Hi, I'm Jonathan Margolis with the State Department. And what I'd like to ask you to do, this may not be possible, but I'll beg your indulgence. I'd like to just give you a hypothetical and ask you how
I know, this is what we do to our students.
how would you look at this through whether it's Nagoya or the individual countries that have already enacted domestic regulation? And here's the hypothetical. So let's say someone learns of a case of someone infected with H7N9 in China and goes over there and gets the individual's permission to withdraw blood and uses his solar or her solar gene sequencer and takes that blood and sticks it into the gene sequencer and then moves the digital information from that over to some other company, which then makes use of that information for whatever commercial or other purposes are necessary or useful. What laws apply in that case?
Actually, Nagoya and CB don't relate to human genetics.
Although China's law
China's does.
yeah. So China decided to go beyond CBD and include human genetic information.
Yeah.
in
It
its law.
actually depends on whether you define animal to include human, because it talks about animal resources. Are we animals?
Yeah.
Right?
Yeah.
Right.
Yeah.
So we need to change it slightly because CBD is very clearly not on human, and Nagoya picks it up. But I think your point of the information legally collected, digitized, put forward, and then used by a third party who is not part of any agreement, how does that trace in and who's responsible for what?
Yeah, and Len's got, I think, the crux of the issue, which is if the material itself never crosses a border.
Right, right. And I think that part of what, at least my sense from reading the Andean law and the Brazil law, was that they were precisely trying to get at that because they include information. Well, the Andean law specifically talks about information, and the Brazil law, one can go back
It
and
uses
forth.
information, but
Right.
in a way that.
But I think that clearly, so in preparing this paper, we had a colloquy with a colleague two degrees of separation removed, but ultimately we got him on email. He's a Brazilian expert, and he thinks that Brazil has every intention of applying their law to information.
We have a Twitter question, Todd. The question is, the databases of NCBI, GenBank, the NIH have more than 320 million sequences. What's their position on this issue?
I advise NIH on IP issues. I've never been asked to advise them on Nagoya issues. I don't think they even have thought about them.
Oh, yes, they have.
They have? Okay.
They're
all
part
right.
of the interagency.
Okay, they have thought about them. All right, then I'm wrong. So what's their position?
Their position is that people put it up willingly, and it is, and therefore it's perfectly legal. Certainly, if you get funding from NIH insists that you put it up so that we don't create an anti-commons sort of system. And if you look at Brazil, you will see that there were almost no, for a period of about 8 years, no researcher in Brazil did put anything into GenBank because of fear that Brazil was going to use the law in terms of information. And what happened was that there was such a complaint within Brazil, especially from the science and technology community, that they were losing out grants, international grants, because they weren't publishing their genetic information, that the government actually shifted its interpretation. So I'm interested that you think that that I'm sure there are lots of people there who would like Brazil to use the information component of the law, but it has already been modified out by regulation in terms of both the S&T and the ag communities. So there's a fight going on in Brazil between the Environment Ministry and the other two right now on information. The other two have won, so that Brazil is publishing genetic information to GenBank to other places with full understanding that it is now up and out into the public. The question that they want, and GenBank has refused, is that they would like to have a flag in GenBank that says that the information was collected under Pick and Matt, and then referring back to the agreement, which the agreement then may say you can't use it for commercial purposes.
I'm not referring to information that is voluntarily put up there under mutually agreed terms. I'm talking about what happens if the information is secured in some way that is not under MAP provisions. And so that's what I was talking about when I talked about, so yes, absolutely, I know the NIH has a policy of wanting any researchers at funds to put their information up, but what about the situation where the researcher is using tangible material that they didn't get under MAP provisions and then puts the information up? Did they have the right to put that information up? I don't think NIH has thought about that.
well, NIH just thought about it, but
Oh, maybe they
whether
have. Maybe they have, but that's what I was referring to.
Whether
not-
they enforce it or not, it is actually part of the NIH agreement that every researcher signs, that it says that they won't do that, and that they will fulfill all of the obligations necessary to collect, as does NSF, as does the Smithsonian. Some of us enforce it, others simply have people sign it. So there will be an interesting case at some point of someone who went and took a handful of soil and put it in their bag, took it back, analyzed it, found something, and didn't have the proper permits, even though they signed an agreement with their funder that says that they would.
Right.
We haven't had that case yet.
I have a question from email. So the question is asking, does the panel have a guess at, or do they know how many Symbio publications, and I'm assuming this means research publications, or commercial projects would fall under the CBD or Nagoya Protocol regulations currently, or that have fallen under those in the past couple of years or so since it's been enacted?
Well, I think a lot of that would turn on whether you think information falls under CBD/NP, because a lot of what we're talking about, at least what I've been working with, is just pure information.
I mean, the research community, this is 20 years in. Certainly, people who do research on the collecting of materials work tirelessly to get the right permits where they go. Some places it's not possible, and that is frustrating. And then as you said, sometimes they change daily, as different people interpret them differently. The hope for Nagoya is that it would set a single standard and reduce those transaction costs, but the way it ended up, it's unlikely that we're going to see that occur, because it still goes back to the same national processes that we had before. So we don't have cases. There's lots of accusation of lots of biopiracy. But if you go through it, there are very few cases of what I would consider to be legitimate biopiracy, i.e. post-CBD, someone not either having agreements that they didn't fulfill or purposively not going for agreements when they could have, and then commercialization. Of the few that are out there, one of the products made $32,000. So the amount of money that has been spent on finding the biopiracy is much higher than any of the damages that said biopiracy has shown to have, because the companies that are investing lots of money are careful. They listen to the debates and coming to them, and I agree with you. I mean, the difference between a scholarly and actually being there where people are screaming at one another on the biopiracy and making claims that are just amazing. An enormous amount of money goes into that community, but we just haven't seen the losses that would justify the amount of money that's going into this process.
I'll just add, it's not just about the information. If the analysis by Artie and Margot is right, that this is triggered by utilization and it encompasses all existing supplies around the world of stuff that was removed from in situ, then obviously there's a lot more publication going on.
That's a good point. Yeah.
An additional point to Len's about folks doing the right thing. The problem that apparently Monsanto has run into in India is local entities that, or at least they're blaming local entities for not complying with the law. And so to the extent that folks are partnering and not perhaps, I don't know, going through the checklist on their own, that could be the problem or problematic.
Big public relations exposure.
Mm-hmm.
So I want to sort of maybe throw another wrench into this and expand on potentially, I think, this word of derivatives, and particularly with synthetic biology when we're talking about parts, and how this notion of parts and constructing numerous parts together to make a final sort of machine or whatever you call it, how the Nagoya Protocol and CBD deals with that. Are there definitions within there that explain what genetic material is, and are they referring mostly to the full sequence? Is sort of what I'm getting at. So the sequence versus components of the sequence, and how you would deal with that if you've got a genetic machine that potentially has 100 different parts in it that in theory could have came from 100 different countries.
Well, that's where the anti-commons issue is particularly huge, and I don't know. I mean, I take it that functional units of heredity is not defined in any of the relevant documents. And so if one were to use a U.S. legislative history type approach, which is you look at what it would have meant at the time that the CBD went into force, I don't think parts would necessarily fall into the category of functional units of heredity. However, there are those, and Margaret can speak to this, who think that that the term is sufficiently broad that it should have an evolving meaning, and that I think is part of the issue.
Right. So I was talking to one of my colleagues who is an international law scholar, on the interpretation of treaties, and apparently there are two schools of treaty interpretation, and the traditional school is a contract approach, that a treaty is like a contract, and in contracts people use specific information, and then they use more flexible standards to take account of the fact that things may arise that they haven't thought of at the time. And if you look at treaty language in the same way, we have standards kind of language that is malleable, and as times change could be interpreted differently, versus the view that it is set in originalist, that it's more like legislation, and you look at original intent and what did the framers think at the time.
The CBD language is purposively mushy and hasn't been in 20 years successfully defined in a clear way, and that's one of the problems. And one of the things I should have said at the beginning, even though I'm part of U.S. negotiations, I'm not speaking on behalf of the U.S. government or any U.S. positions or even Smithsonian positions. I'm talking as someone who's been involved and a political economist who's been engaged in this, so I get that on the record. I think we're in a fascinating time when the times have gotten well beyond the expectations of the treaty. So it allows for contestation because people simply really didn't know at the beginning, and they certainly don't know now what a lot of these terms meant. On the utilization trigger, as a trigger that would start the obligations of the treaty, yes, there are some who push for that. I would say very few are government types in any government. So that tends to be an NGO or sometimes lawyer, but from an NGO perspective. And it was, again, clearly not the intent, because the intent was of those, that were utilized under the terms of the treaty, and under the terms meant that you had mutually agreeing terms. So things that you were before or that you don't were explicitly in the intent of the negotiations not to be covered. And the Europeans in the last 15 years in the negotiations, have used that as sort of, we can accept almost anything because we have Article 15.3. So, should an alternative end up being acceptable, there are a lot of people who have been depending on it not being, is the nicest way. But when you do the agreements, the mutually agreed terms, what we've been doing, certainly from the research community, is writing in triggers, which is that a particular type of use. So we want to do it for systematics, for taxonomy, for understanding, for conservation needs. Any use is possible. But when you want to start using the material for bioprospecting, it triggers a new obligation to go back for a different agreement. The question does arise that, however, if you've published, what happens? So the whole CBD is an anti-commons. To bring it to the fullest extent, which in some places it is, it's an absolute anti-commons. It's against publishing anything. It's against every utilization has to go back to fundamental principles, and that was not expected, but it is how it's turned out, and it is one that at some point will have to be addressed.
All right, so we are at 2 o'clock, so I wanted to take the time to thank our panelists for discussing these, what are clearly easy things to solve. So, but again, I'd just like to put a plug out that we're going to be continuing this discussion and activity in this area. So please get in touch with us here at the Synthetic Biology Project at the Wilson Center as we move forward in this. So with that, I'd like to thank our panelists again.